Thank you very much, Carolina, and good afternoon, everybody. And it's good to see so many of you have stayed this long this afternoon. And I hope this last session is interesting for you. When you're the last speaker of the day, it always presents certain challenges. So the first one I say we've overcome because you're all here. The other one is that you worry that what you've prepared will already have been said by all the previous speakers. Sometimes that's right, but I've been making copious notes, and as you know, there have been various things that have come up during the course of the morning, which I'll address some of them as I'm going through. So you might not get an absolute reflection of the slides, but I'll try and deal with some of the points that have cropped up, and then I'm sure we'll come back to some others of them during the discussion. So I'm not going to spend very long on the legal framework. You'll be pleased to know I wasn't going to anyway, actually, but. A few things to draw out. It's important, I think, to remember that we're talking about fundamental rights. And fundamental rights don't exist in a vacuum. They exist for citizens. They are the rights of citizens, and they have a fundamental right to good administration, a fundamental right to public access for documents within limits, and a fundamental right to complain to the Ombudsman. And as the administration, I mean, these have a context, and the context is the democracy of the European Union. And we do well to remember that in all the work that we do. And I know from personal experience that sometimes these things that come across our desks are a nuisance, they're time consuming, but we have to remember that they are all based in the rights of citizens. And if they are abusing those rights, then I believe that there are appropriate ways of dealing with that, of tackling it, challenging it. And the Ombudsman, I think, has a good track record of upholding the work of the institutions when they do say enough is enough. And the Ombudsman experiences that as well. And certainly, whilst I think there could be an improvement in 1049, and actually, whilst I'm jumping ahead of myself here, one of my recommendations is that I would not be averse to an explicit provision in 1049 to address that thing, that issue of the vexatious use or abuse of the right when it is when it is excessive, genuinely excessive, and a number of the laws in member states do actually have a provision like that, as you might have known from my CV in the documentation, or if you've heard me before. For many years, I was the Deputy Information Commissioner in the UK. I oversaw the introduction of and the implementation of the Freedom of Information Act in that country, and that is a country which has a very explicit provision which discharges public authorities from the obligation to deal with vexatious and repeated requests. That itself became quite a contentious provision in that law, and indeed there was litigation over it, as you might expect. It's almost self-fulfilling that there's going to be litigation from over an issue which is designed to deal with a potentially vexatious requester. But I think as a matter of principle, I think we have to say that these fundamental rights are not without limits, and that there could be appropriate provisions to prevent abuse. I would say that there are some already, and I will come back to that. The other thing that I want to draw out from this slide is the fact that the Ombudsman is an alternative remedy to a court when the right of access to documents it has not worked out in the way that the requester would like. It's right that they are mutually exclusive. The Ombudsman is prevented from in her statute from dealing with any matter which is before the courts or has been adjudicated on by the courts. But I would say that the key issue here is around the time limits and around the remedies. So time limits first. If you want to challenge the decision of the institution, and I'm saying institution, I'm including obviously all the agencies, etc. If you want to challenge that decision in the court, you've got 2 months in which to do so. And so waiting for a decision from the Ombudsman, even though, as I'll say later, we've considerably speeded up in terms of our decision making, you're not likely to get a decision within 2 months. So you really have to make a choice. And I think that that choice should be informed by, and if I can leave aside, but without belittling the huge issues around access to justice that there are, that were referred to this morning, the choice should be partly informed by what you're seeking as an outcome in terms of a remedy. Because if you are seeking a legally binding ruling, then obviously you have to go to court. The Ombudsman, even if she finds that a document should have been disclosed which hasn't been disclosed, she can only make a proposal or a recommendation to the institution, and they are not legally obliged to follow it. So that is one aspect to consider. Consider also, what is the role of the Ombudsman? The role of the Ombudsman is to deal with instances of maladministration by the institutions, and her role in relation to access to documents is slightly odd. Regulation 1049 is the only regulation that specifically refers to the right to complain to the Ombudsman, because it is a general right provided for by the treaties generally. But 1049 gives a right to complain to the Ombudsman as an alternative to court, but she has no specific powers under 1049. She only has her general powers in relation to issues of maladministration. So, for example, she cannot make a formal recommendation that that a document should be disclosed unless she makes a finding of maladministration. Maladministration is where there has been a breach of the law, but it's also where things could have been done better, where she thinks that things that say options were not followed by the institution, which would have provided a better outcome for a citizen. So it's a much broader concept than non-compliance with the law. But I think one of the issues we have with 1049 is that it is very much seen as a legal right, and the way that many people, I'm conscious that I'm talking here primarily to a room full of lawyers, the engagement with that legal right is often done, I would say, on a fairly kind of combative basis, and that people get locked into positions on this, and that by the time something comes to the Ombudsman, an institution, it seems to us, can very often, and I'm simply making an observation here, I'm not being critical, an institution can become very defensive of its position. Very often its position has been reached through a lot of very hard work, as we've heard, and through a significant decision-making process in itself, which will have involved lawyers, and it will have involved quite often politicians. And so for people to kind of resile from that situation, I know can be difficult, and I don't underestimate the practical difficulties of that. But nevertheless, given the Ombudsman's role under the treaties to try to improve the way that the institutions function, the Ombudsman, I think, should be listened to, and her recommendations and proposals should be taken seriously and considered. Again, I'm not saying that they're not. I'm just saying that I think you need to think about this overall scheme of 1049, the role of the courts, the role of the Ombudsman, and the powers of the Ombudsman when we're looking at this issue, and particularly this issue of the alternative remedies under 1049 of court proceedings or a complaint to the Ombudsman. And I'll say it because I made the note on this page. And it was, again, in response to something that came up the way. One of the things that the Ombudsman can do is address the issue of proactive disclosure. You know, she can provide commentary in her role of trying to improve the way that things are done, to make suggestions about how improvements could be done. Even if you can't do anything or won't do anything about the present case, she can make suggestions for the benefit of the institutions as to how they might do something differently and how they might improve. And that may or may not be coupled with a proposal or a recommendation for something that can be done in the instant case. And it's right, of course. So it's almost trite with this audience to say that, but the point was properly made this morning, I think, that a court can only adjudicate on what's before it, and what's before it is a particular case. And there's the famous expression of, you know, hard cases can make bad law. And there can be unintended consequences. A court has the luxury, actually, of not having to think through the consequences of its decision for the vast array of circumstances which its decision at some time in the future might apply, where it might apply. They don't have to. Again, I'm not being critical of anybody here and the way that they discharge their function. I'm just saying that this is the landscape that we are dealing with, and it's not straightforward. And that's before you get into all the various functions of the institutions and all the things that we have to get our heads around. And whilst I'm sympathetic to the idea of resources, I would just like to point out that 2/3 of the Ombudsman's access to documents case handlers are in the audience today. And they have to get their heads around everything that the whole of the Commission does, the whole of the Parliament does, the whole of the things that the Council do, and all the agencies. So, you know, it is the whole issue of, we might be dealing with a small issue of the law, but in terms of the circumstances in which it applies, you know, it's pretty much life in the universe. And they love it. Don't you? A few further observations, and again, these are observations and not actually kind of recommendations. The first is that why do we have the law? We have this law because it sets down minimum requirements on public access to documents. It's the fallback position. I think you know the implication is, and it doesn't, is that you know, the more proactive transparency that there is, the fewer requests for documents there will be. I'm not sure that's actually totally borne out by experience, but that is the theory. And I think that, but my point really here is that it's about, there's an issue about approach. The law is a set of minimum requirements, and it isn't necessarily definitive. Transparency is a very wide concept, as we've said, and there are drivers for greater transparency. And there are many drivers at the moment. And frankly, you know, decisions under Regulation 1049 are not the biggest drivers for greater transparency, nor should they be. Because Regulation 1049, from my point of view, it's a fallback position. It's a fail-safe for when appropriate transparency is not otherwise given. So at the moment we have huge drivers for greater transparency in issues about truth, about accuracy of information, to combat fake news. I think that was a point raised this morning. The fact that you know, transparency and accountability does engender greater trust in the institutions. Again, it doesn't always, because it depends what's revealed. You know, I mean, again, if what's revealed is through transparency is corruption or an abuse of an expenses regime, it's not actually going to enhance trust. But that doesn't mean to say that you shouldn't be transparent about it. And one of the things, again, that the Ombudsman tries to do is to recognise good practice and give praise where it's due. For example, in her Award for Good Administration, I'm going a bit off the topic here, but it's important that again, a different role to that of the court. The Ombudsman is about improving the administration of the institutions, and so part of that is giving praise where it's due. And so the Award for Good Administration is a means of showcasing the excellent work which is done throughout the European Union by its institutions and agencies, whereas otherwise the focus is just on, by definition, what comes to the Ombudsman is situations where a citizen sees things have gone wrong and things could be improved. So again, this is part of the context, but transparency is a theme which runs through everything. We've talked a lot about citizen participation, and of course, yes, that is a key purpose, but that's not the only purpose of transparency and Regulation 1049. A lot has been said about the need to update 1049 because of the improvement of technology, and the fact that now we have so many more sources of information and media of information. I was particularly pleased here to hear about the link in your section, Maria, between document management and access to documents, because I think the two are inextricably linked, and I think there's going to be a much more important link as we are moving more and more towards electronic document management. I mean, although there's mention in 1049 of electronic communication and the electronic means of holding documents and proactive disclosure, it's really written with a paper-based system in mind, and you have to again bear that in mind. I agree, and again, perhaps jumping ahead, I agree with everything that Maria and the other speakers were saying about the position that we're in, about the prospects of Regulation 1049 being reopened, and something, as I would call it, positive, constructive, coming out of it, and just getting all the good things that we would like to see in an improved regulation, because I think we would be opening Pandora's box, and there are, again, as I'll come on to, many different sort of views about what is the appropriate level of transparency. Citizens' expectations, I think, clearly are important, and they're growing. Citizens have an expectation through their access to technology and information now to have the information that they want when they want it quickly. And this means that they tend to be impatient, and they often do not understand or will not feel that they have to tolerate the established bureaucratic political reasons and for the time that it takes to make some of these decisions which are contentious in the institutions. Again, this is an observation. So matching your performance as a public authority or with the expectations of citizens, I think, is an increasing difficulty and challenge in this whole area of granting public access to documents. So, you know, we come to the big question there that everyone's asking, which is whether Regulation 1049 is fit for purpose, and we're going to have a bit of a discussion about that. I'm still really on issues of practice as opposed to the law. And the reason that I'm concentrating on these is that I think endorsing the conclusion that changing the law is not really a viable option, much as it would like to be. We need to think why are we having that conversation? Why do we think we need to change it? And it is partly because we think we could have a legal instrument, a better legal instrument. But surely what we're looking at is the way that it works in practice, and the reasons why we think there might be a need for reform is because we think that the current regulation doesn't work, or doesn't work as well as it could if it was improved. So I think if we look at some of the issues in practice and look at how the current law can be improved upon, then I think then we might be getting somewhere, and that's where there's the option to change. And if I may, sorry, Anne, I haven't talked to you about this, but I think that was the way that this morning you were articulating Client Earth's position. It wasn't that you thought that Regulation 1049 was the best thing since sliced bread. It was that it is what it is. It's not that bad, and a lot more can be done within the regulation and the way that we operate the regulation without necessarily changing it. And certainly I think that's my position, and it's certainly what I think we should be concentrating on in terms of looking at practical improvements. So we've talked a bit about the lack of consistency. We might not have used that phrase exactly, but there are different outcomes for citizens when they're making their requests, and these are not always well explained. I mean, we've had we've seen some examples this morning of different outcomes in very similar cases from the courts, and I think we had those two emissions cases that were raised where you think, well, really, we've got two different outcomes, and why? Again, courts don't necessarily have to think that there's a doctrine of precedent, but when you're looking at all the circumstances of a case, to use a well-known legal phrase, you can get inconsistent outcomes, and or apparently inconsistent outcomes, and it happens. We see, having an overview of all the institutions, that different institutions, different agencies, sometimes different DGs will approach the same issue differently. So what appears to be the same request to one DG might get a positive response in the information is disclosed, whereas the equivalent information in another DG is not disclosed. Now, there might be some subtle reasons for that, but as far as the citizen is concerned, it appears to be a different outcome and a different consistency. We've heard about different cultures, and the obvious manifestation of this was in the very open and honest answer that we had about the dynamics in the council in relation to the issue of the reform of 1049. I've sometimes wondered if we could suddenly have the Finnish presidency followed by a Danish presidency, followed by a Swedish presidency, followed by a Dutch presidency, then maybe we might stand a bit of a chance of getting some traction to this issue, because it would take more than 6 months anyway. But you've still got the issue of the qualified majority, because you're only the first among equals when you're the presidency. But sorry, I have to have these little fantasies sometimes to get me by. So the issues, some of the issues that we feel we see in practice is it does feel sometimes as if procedural obstacles are unnecessarily put in the way of some requesters. And I know that the law might provide for them and they might be justified, but do you really need to see an ID card of a person before they're entitled to a request? Do they really have to provide a postal address before you can legitimately respond to their thing? If they want a postal reply, they can, but if they've asked for a reply by email, why can't they have a reply by email? And if you're fulfilling the request, like you do in so many of the requests anyway, does it matter? We hear the argument about legal certainty, and I understand that argument, but it's only going to be relevant if somebody needs to fall back on their rights. And I know then you can say, but you don't know in advance whether somebody's going to have to fall back on their rights or not. But I do think a more flexible, subtle approach would sometimes be more citizen friendly. Great to see the progress which is being made, though, in terms of the email system, the e-signature system, which I know is coming online, improved websites, more proactive disclosure. All very good, and I think that is the way forward, and hopefully these issues that may be perceived as obstacles are not going to become relevant in the future. Yes, delays in the system do sometimes appear to be unreasonable. They are not always unreasonable when we understand the reasons. And so this is where dialogue is important. And whilst, as Päivi said this morning, communication is a separate issue, but actually communication can help to reinforce the way that public access to documents and access to information can work. It also tends to help because it can help the trust issue indirectly. It can help to get us away from this competitive approach. I'm not denying that there are some awkward customers who make very unnecessarily unhelpful requests and who do not respond positively when you ask them to clarify or cut down the request. I know that they are. But you can't operate on the basis that everybody's going to be like that. And the vast majority of people are reasonable, and if you pick up the phone and explain a problem to them, explain why something needs to go through certain processes before it can be communicated back to them or a decision can be reached, most people will, I think, accept it. And if they don't, you've actually, if you're bothered about a complaint to the Ombudsman, you've actually got your defence in first. Make a record of it, of that conversation, and we're not looking to trick people up. We just want good administration, and we want citizens' rights to be properly respected. And that is not just about legal rights; that's also about the way that they are treated. Let's not talk about upholding the public interest, although I do think that is an issue. Data protection we've talked about. I think in practice, the rights of data protection rights of citizens are put on a far higher legal and practical pedestal than those of public access to documents. And you'll see when I come to one of my recommendations, I think this is a big area. It's also a big area where we've got huge cultural differences, as we've heard about, as we saw in the Finnish tax example, and certainly with Sweden and the tax example there, where this information. I mean, you talk to other EU citizens and explain this openness of tax information to them in Sweden, for example, and they blanch, absolutely kind of go, what? How could you possibly? Because it is just so countercultural to the way that personal information is protected and private life is protected in other European countries, and yet we're all one European Union, and we're all supposed to be playing to the same rules. The reasons why we had a regulation for data protection to replace a directive is because the Commission was concerned that you had 28 member states and 28 different ways in which data protection was being enforced. And actually, although we've highlighted this morning one of the provisions which still had to be negotiated to get the regulation over the line, so that member states still have that bit of wriggle room so that they can make their access to information laws compatible with data protection. I mean, all credit to the Commission for actually going for it, and it's not just because you're here, but I really salute the work that the EDPS, the European Data Protection Supervisor, has been doing to try to get this done. And it's not the European Data Protection Supervisor who thinks that the balance between public life and private life is where the courts have drawn it. It's the courts, and whilst we're stuck with some of these cases like Dennekamp and like Bavarian Lager, which for me as a UK citizen and with my culture, those decisions are complete anathema, and yes, and I'm not making generalisations about culture, but we can all say we can all reach agreement in this room, but we just have to be aware that the dynamics at member state level are very different, and I can't not say that's why the position of member states in legislative processes are so important, so that we have a better understanding of how decisions are reached, because somebody in Sweden will not understand the position that is taken on this balance between public life and private life. Sorry, I'm in danger of getting carried away and taking too long. So I just want to say a little bit on access to documents about what the European Ombudsman has done to try to speed up public access document in addressing this adage of access delayed is access denied. I know it's a bit sort of contentious and perhaps has caused some problems within some of the institutions, but it works well in some areas, and I think if I'm being honest here, and I am an honest, open, transparent person, what we need to understand in the Ombudsman's office is where it genuinely causes difficulty because of the internal process that you have. And we're in dialogue with Parliament about that issue. We've had a dialogue with the Council about the issue. It seems to be working well at the initial stages with the Commission, and I think that's because they have what I consider to be a very robust process for dealing with the initial applications, which are, as we've heard, are dealt with in the directorates, and then the fact that it's in Maria's section in the centralised in the Secretary General, where they really do a thorough job on the confirmatory applications. We see how different decisions are taken at that stage, and then if we get a complaint against the Commission against their confirmatory decision, they've done the work. They don't need to add to any more, and we can just go forward from there without having to have the position of the and that's really how it should be. Sometimes we get that elsewhere as well, but that for us is where it's working well. And we can only, the only thing that we can really speed up, and the only thing that we can speed up is our own internal processes, and that's where we've done that, and we've set ourselves targets. Sometimes it seems that we've set the institution too short a timescale as well. But again, just like I'm saying you should pick up the phone to the citizens, and if something that you get from the Ombudsman causes you a problem, pick up the phone to us, because we're human beings too. And Overall, while there are exceptions, overall, what we've seen in the first year operation of our fast track system is a 3 times improvement in the way that access to documents complaints are handled within our office to getting some kind of outcome or resolution. So this is my last slide, you'll be pleased to know, and this is focusing again on future prospects, but I did this really from the contextual point of view. So I think we're seeing growing citizen engagement generally with political issues and life in the member states and in the EU. I think the biggest obvious area where we're getting it, and we've seen it in relation to some of the cases that have been discussed this morning, is in the environmental area, because of the concerns through the generations of climate change. And I think with the youth interest in this area, this is something which for the future we're really going to see. And this is why I think that the focus on the Aarhus Convention and on the environmental information regulation is just going to grow and grow. And I think that that's going to expose the fact that not only, as we heard this morning, is there a lack of awareness in the institutions about the environmental information regulation and the different rules that apply. I think there's a lack of understanding and certainly a lack of appreciation application in the way that the courts have approached this up until now. And I think they'll be forced to have a more careful look at it. And actually my own view is that I would question whether Regulation 1367 itself is compatible with the Aarhus Convention, because I don't see it, and I think, you know, we've touched this morning on the different exceptions that there are in the Aarhus Convention and the regulation, as opposed to 1049. Sorry, not in the regulation, in the directive and the convention. But the convention applies to the EU because the EU is a signatory, and yet Regulation 1367 throws you back on the exceptions in 1049. And there is a significant mismatch, not just in the fact that they're all subject to public interest in environmental information, but you know the decision-making process as such doesn't feature in Aarhus. So there's got to be some matching, and that I think is an important area where, you know, on my wish list, the reform of 1049 could do something really important and significant. It could improve the way in which, particularly the environmental information regime, but also data protection and other regulations which make provisions about public access to information, the way that they, I was going to say join up, the way they don't join up at the moment. And I think we would all benefit if there could be more clarity around that. I think I'm nearly there and have nearly made all of my points, apart from this issue of actually discussing the recommendations. So I don't know if you want me to go on and raise those now, or whether you want to save it for a debate. No, I'll raise them now quickly. So it follows really from what I've said that I think, you know, there are some issues that can be addressed under the existing legislation, and this is very much about practical issues and about handling strategies. There are some things that can be dealt with or could be dealt with by actually getting greater clarity around the law, and there are things that could be done by some clearer exposition of ombudsman powers under 1049, if we think that they don't fit terribly well with the general powers of maladministration. So on the handling things, you know, I think it's for institutions to look at how they manage requests. There are provisions now for dealing with large and multiple and repeated requests. and use them to challenge some of those requests. I know it can make an entertaining presentation to put up some ridiculous requests, and some of them are ridiculous, some of them are time consuming, but there are provisions, as I was saying earlier, in the regulation where you can be challenged, you can go back and seek clarification, and I mean we had a case, I think it actually is with Parliament, recently, where the Ombudsman upheld the institution's view that they had gone back to the requester, asked him to narrow it down, and either he hadn't narrowed, he'd refused, or he hadn't narrowed it down sufficiently for the institution to reasonably deal with it. And we upheld that position of the institution to say, no, you've done as much as you can, you've discharged, there's no maladministration here. The institution was perfectly entitled to go back to the complainant and ask them to cut the request down, and he didn't. So sorry, that's it. Communication and managing the expectations of requesters is important, and not just sort of for dialogue. But if you want to prevent these things, I mean, one idea that I had is, it's putting information on your website, especially because not only might it be read, but if it isn't read, you can point somebody in its directions. Put some guidance for requesters on your website as to what you would expect them to do and what you look for in a request. What makes a good request? You've said that client Earth's requests are great. I'm not expecting them all to be that standard, because most citizens are not lawyers, and a lot of requests come from ordinary citizens. But again, one of the things that as Information Commissioner in the UK we did was we put guidance for requesters as to how to make a good request and not fall foul of the provisions about vexatious requests. So we did guidance for the authorities about what they should do and how they might identify a vexatious, or what we saw as being a vexatious request. To complement that, we gave advice for requesters as to what we looked for in terms of a good request. And again, hopefully it will be read, but if it's not read and not respected, then all you've got to do is, as a first point, is refer the requester to that sort of guidance. So is there more that institutions could do to help themselves in that respect? I do worry that, as I was saying right at the beginning of this presentation, about sometimes the legalistic nature of the approach is one which drives us down a kind of a combative route, and that instead of thinking, is there really a problem with disclosing this information, that the natural reaction on getting a request is, do we have to give this information out? Do we have to give this document out? Is there an exception that can apply? Oh yes, I think, oh yes, that one, and maybe this one. What's the strength of our arguments for resisting it? As opposed to thinking, what is the harm? Is there harm first? Would there be harm? What would it be? If so, does it fall within the exceptions? And if relevant, nevertheless, is there a public interest which would apply to override this? I mean, again, I know that this is the approach that the courts have taken, but the fact that the courts have suggested that really it's for the requester to come up with the public interest arguments for the disclosure of a document, I think is quite shocking. They don't know what the document is. Yes, there may be registers to help them identify it, but they don't know the content. That's why they're making the request. So how can they mount an argument to say there's a public interest in that content being an overriding public interest in that content being disclosed. And it's the same in terms of the the approach to necessity under data protection. In my mind, the courts have put the onus on the person making the request for personal data to demonstrate why it's necessary. And we saw it in the Dennycamp case. In the Dennycamp case, yes, there was this issue about identifying a conflict of interest, but it's not very often that you're going to be able to make that sort of judgment. The GDPR now and the equivalent EU regulation is a slight improvement on that, because it talks about necessity in the public interest. But still, the onus is on the requester, who almost by definition doesn't normally anyway know the content of the document. So there is that. For me, there's that sort of issue. I've drifted a bit there into the legal issues, and one of my themes on that is that in terms of the 1049 and the case for or against its revision is actually, for me, some of the problems with 1049 is the way that the courts have interpreted and applied it. And you're not necessarily going to solve that by changing the law itself. So yes, joining up with the other regimes, I do think that there might be some benefit from looking again at the definition of a document, because the previous, the current regulation was drawn up with paper in mind, and we've moved on. I do have some concerns about institutions layering on top of the legal definition, their own definition, and your own internal rules. They might be helpful in practice, but they can't override the law. And I think we've got that in the comitology, the Bees decision that we've been talking about. Again, one of the issues in the arguments that the Ombudsman says, okay, so you've got internal rules about comitology. But that's one factor, and internal rules cannot override a regulation, so they need somehow to be reconciled. I'm not going to get into the competition about who hates general presumptions more, but I'm certainly well up there on the leaderboard, and I think they are a significant. I can see the attraction in practice, but I think they represent a significant erosion of citizens' rights of access to documents. And then finally, I think on the Ombudsman's powers, this isn't, if you like, Ombudsman's policy, and it's not. I can't see that it's likely to happen anyway, because again it would be tied up with the revision for 1049. But as I said, we've got this slightly odd position where there's this explicit reference to a complaint to the Ombudsman in Regulation 1049, and yet and that's a legal instrument, and so we're looking at, is the law complied with or is the law not complied with, and that doesn't necessarily sit well with the Ombudsman's general role in terms of maladministration, which is why I'm saying if you want a binding legal ruling, you have to go to the court for it, which brings me back to that earlier point. So I do think there's more questions than answers. I do think, and I hope I've demonstrated, that I think it's a very complicated landscape. I think that the idea of reforming 1049 is one of those, wouldn't it be nice if, but at the same time be careful what you wish for. Thank you very much.
Thank you.